The most important document in all of your real estate transaction is the title to your land. Because after all, that is what you are buying. Sure, you get the piece of property, but you need the piece of paper that shows that you own the property. But that's not all that's involved in a real estate title. When you're purchasing a property, what you likely want to do is review the title to make sure that there's nothing wrong with the property, or maybe that you're even dealing with the actual seller, so that you can discover things about the property that might be important to you for your use of that property in the future. So basically, so you know exactly what you're buying. And also to find out if not only, as I said, the person that you're buying from is indeed the person you're dealing with, but if in fact they are able to convey the property to you, because without being able to convey the property to you, well, you don't own the property. So in today's video, I'm going to show you how to read a title here in the province of British Columbia if you're purchasing or reviewing a title for any reason. And hopefully that will help you understand the real estate transaction a little bit better, because that's what I try and do here on the channel. My name's Steve. I sell real estate in Surrey and the Fraser Valley. And of course, I like to educate you about the real estate transaction. So if you'd like to educate yourself on what it takes to buy or sell real estate, or maybe you're just interested in the marketplace, please go ahead and subscribe to the channel and click the like button to help me get this video out to more people who are trying to figure out this whole title thing and exactly what's going on. And if this still doesn't make sense to you and you need help in, again, my area of Surrey and the Fraser Valley, well, you can book a call with me right now using the link in the description below. There's other good links down there as well for you to check out. But let's hop into now. I Googled example title, and guess what came up? An example title. I wasn't really going to use a real client's title because, well, that would be a privacy infringement, which I am apparently not allowed to do. We are fiduciaries. We have to keep our clients' information completely confidential. So this is not a real title. This is just a fake one I found from the internet. It's going to help us understand what the heck is going on, what we should be looking for. Sure, every part of the title is important, but I'm going to tell you, as a general rule, this top section here, you can pretty much ignore it. I mean, for the most part, yeah, I mean, do you care the land district of where the property is? Sure, you might. But realistically, this top section isn't really going to tell you a whole lot. What you want to do is first go down a little bit, and you're going to find out who the registered owner of the property is. If you're purchasing a property, the name on the contract better well be, in this case, Joe and Mary Smith. Now, you're going to see that beside that is their profession, so you can help identify indeed if that is the right person. All titles are registered at Land Title with the owner's profession at the time, and then obviously their address. Now, their address is their mailing address. It may be different than the address of the property, so that is something to consider, but you want to make sure that this is the person you're dealing with. Now, obviously, you're probably dealing through your realtor, but I'm talking about the seller. We need to make sure that this indeed is the seller that is being dealt with. The listing agent has a duty to make sure that it's the right person. But you as the buyer, if you see a different name here, you're going to want to find out what's going on. Is it a power of attorney? Is it an estate sale? So all these different things that you can look for. One interesting, super interesting point is this here, where it says these owners are joint tenants. There's two different ways a title can really be held. You can be held in joint tenants, or you can be tenants in common. Tenants in common, the easiest way to understand that is it's a percentage basis. So maybe 99% ownership, or 50-50, or 60-40, whatever that happens to be. Joint tenants is both of, I guess the owners in this case, own the property together as a whole. So they both together own 100%. The easy distinction would be to kind of understand that a little bit better. Is that the same as 50-50? It's not. If it's a 50-50 tenants in common situation, and one of those people were to pass away, the 50% of their property would now go through the probate and estate portion of things, as opposed to a joint tenant, which most married couples would be. The property just immediately transfers to the spouse. You don't have to go through any of those other legal loopholes. So a little difference between joint tenants. Doesn't really matter to you as a purchaser necessarily, unless, for instance, you're buying a portion of a property. Then you would want to take a little bit closer look at the joint tenants versus tenants in common. Now, they're most likely, in most cases, the address that's here is going to be the same address as the address of the property, but This is where the owner lives. It doesn't necessarily mean this is the property you're buying. To identify the property you're buying, you're going to want to look at, one, the parcel identifier. So in BC, every single property has a 9-digit number. And that should be written here. And then you also have, this is called the civic address. This is the legal address or the legal description. So at land title, this address may not matter. This is really the address of the property. Obviously, you're not going to write that on an envelope. So we have a mailing address and we have a legal description or a legal address. Generally, if this is actually the property that you're buying, you're going to cross-reference these three to make sure that you're indeed buying the right number. If one of those is wrong, you're going to want to verify what the heck's going on. So you have the owners, then you have the property. Then this is where things start to really matter. Let's put it that way. Charges, liens, and interests are going to be registered below this line. Now you have a couple different two main, types of charges on title. One is financial, one is non-financial. So for instance, a mortgage, maybe a judgment, private mortgages, certificates of pending litigation. These could all be financial charges that can be registered on the title. Most often you're going to see a mortgage. A non-financial charge is going to be something else. In this case, there's a covenant and a priority agreement. A covenant basically means a promise. There's a promise registered on this title to, in this case, the city, for something. Now it's your job as a realtor and as a buyer to verify what the heck that is. And I'll talk more about that in a little bit. But generally speaking, financial charges are going to be cleared from the title. You're not going to take over someone's mortgage if they have backed taxes, which could be a charge on title. That's going to get cleared at the time that the property transfers from from the seller's name to your name as the buyer. So those financial charges are going to come off of the title. But it's really important to see the title in advance because, for instance, there's something called a CPL or Certificate of Pending Litigation. That means the person's being sued. That actually might help you in some sort of a negotiation. You can say, hey, this guy's in tough shape. They might have the money. They might not have the money. They might need the money. But most legitimately, a Certificate of Pending Litigation is put there so the person cannot actually sell the property. Somebody's registering a charge against that property to make sure that they can try and recover some sort of funds that they may or may not be owed through a lawsuit. So a CPL or Certificate of Pending Litigation is a big red flag. We got to try and figure out what's going on. And any of these financial charges, you need to understand as, again, a listing agent or as a seller or even as the buyer, that means there's some sort of money tied to the property that has to come out of the property. So it's your due diligence to then find out. Sure, if you have a mortgage, there's a really good chance you don't owe more than the property's worth. But if you've got a mortgage, a second mortgage, a CPL, a judgment, there's a really good chance that, hey, there's not going to be enough money to clear title and the property actually cannot be sold unless there's a negotiation done or unless maybe whoever owns those charges on title waives collecting that money or they try to collect that money in a different way, or maybe the owner has to bring money to the closing table. So it's really important to understand what the financial charges are, but you may not get all of the details. If you just see a mortgage, you're probably fine. If you see a laundry list of other financial charges, well, you could be in rough shape because you might not be able to purchase that property, or if you're the seller, you may not be able to actually dispose of that property legally. So you better not enter into a contract that says you can clear title when you can't. Now let's get into the non-financial charges. So in this case, there's a covenant. As I said before, that's a province. There's a priority agreement. There's something that happens in a particular way that prioritizes one property over another. That could be there as well. This is where you'll see things like easements, rights of way. An easement says you can or can't do something on that portion of the property. A right of way says maybe your neighbor has a right onto a portion of your property, so you can't construct something there. These charges are really dependent upon each individual charge on title, and you have to pull each of them to understand what it is that you're getting with the land, because these are going to travel with the land. The likelihood of a seller clearing an easement off of title is basically zero. So you have to understand that these are the things that are going to come with the land. Now, Now let's differentiate. If you're in a strata style property, so you're in a condo, if there's an easement that says TELUS gets to run a wire on a portion of the property that, is on the north side of the building or wherever it happens to be, and you're just in a condo on the 42nd floor, an easement's like, let's face it, it's not really a big deal. But if you're buying a 7,000 square foot lot, and for instance, in our area, BC Hydro has an easement or a right-of-way over the back 20 feet of the lot, that could be a big deal because now that area is not actually useful. Sure, it can be maybe used as your backyard. Your kids can play out there. But if you want to build a shed, you may not be able to put it in that portion of the yard. Now, that really becomes an issue if those easements or anything are within or extend past any setbacks. So for instance, if I can't build within the last 25 feet of my yard and the easement's 20 feet, not that big of a deal. But if, let's say the easement is 40 feet, well, now I just lost 15 feet of building area and that actually devalues my lot. So it's extremely important as a buyer that you look to see what these charges are. Now, I will let you know with my team, if you choose to buy a property with us or sell a property with us, we pull all of these charges for you. These charges can be something like $25 each just to pull the charge from the land title office. And there could be 15 or 20 or 30 charges. And well, that could get quite expensive quite quickly. So when you work with our team, we actually have the ability to pull these charges on your behalf, have you review them. And believe it or not, we actually get them summarized by a lawyer. So you don't have to try and interpret what an easement document looks like, because trust me, a covenant document, an easement document, a right-of-way document, they're not exactly easy documents to read. So it's super important that you understand those charges and that you don't just skip over them. They're much, much more important if you're seeing them on a freehold property where you own the land, where you want to do something with the land. And they may be less important if you're in some sort of a strata, townhouse, condo, because the likelihood of them affecting what you can do with the unit is probably very, very slim. The last part I really want you to, sure, transfers, pending applications, those are usually none. I can't actually remember any time I've seen those. But this actually might be the most important line on the entire title. Duplicate indefeasible title. You need this if you're purchasing or selling a property to say none outstanding. The reason for that is technically at the land title, there's 2 titles for every single property. And if one of them gets taken out and it's not registered in the land title office, or it's called the duplicate title, then the property cannot be conveyed. Now, generally speaking, you don't see them outstanding. However, back in the day, you didn't get like an appraisal done and a credit check done for a mortgage and do all these things. A lot of the time you just went to the bank and they may have done a little bit of background work, but what they did for collateral against your home is they didn't register a financial charge on title. They would actually just get you to go to land title and you would physically pull out the second copy of your title and you would give it to the bank manager, and the bank manager would quite literally put it in a safety deposit box. And let me tell you, I have listed properties in the past where somebody's lived there for 40 years and I pull it up and it says, oh, the duplicate title is out. And I could not sell that property. They went back. This is a true story. Hand to God, true story. They went back to the branch to see. They were like, oh yeah, we gave that to the branch manager. Believe it or not, it was the branch manager's last week before retirement. They happened to catch him like 2-3 days before retirement. He remembered and he went into his desk and he literally pulled out the title, gave it back to them, which was great. They were able to sell. But if that guy had retired, and this, I don't know, would have just been in paperwork in the shuffle in that guy's desk when he retired, it would have been an absolute disaster. So make sure you do not have a duplicate, indefeasible title out on any property that you're selling or that you're looking to purchase. There you go. That's basically it. The big 5 that I want you to take away from this are: 1, make sure the person's name is the person you're dealing with. Make sure the address and legal description are correct. Know the difference between financial charges on title and non-financial charges on title, and which ones of those you're going to receive with the property, and then make sure that duplicate title is not outstanding. And if after watching this, you feel like you still need help navigating a title and a purchase, and you're looking in Surrey or the Fraser Valley, well, you can book a call with me right now using the link in the description below. Thank you so much for subscribing, clicking the like button. We'll see you in a couple of days.